This video is a summary of everything that was said in the coins alert. Also, don't forget to like and subscribe to my station to get more XRP news and news about cryptocurrencies in general. Look at this now. Why the SEC's Ripple appeal might not be accepted by the court. Now, before we go any further, there is a new crypto airdrop going on Telegram that will soon start. Make sure that you take part in this airdrop. Just below the movie, there is a link. Don't miss this now. Let's keep watching our movie. The SEC's appeal is missing important pieces of evidence, like the expert's testimony that was thrown out and the investor's trust. A court document says that some XRP investors either didn't know about Ripple's efforts or weren't hurt by them. The CC relies on a made-up investor, even though there is no proof that they plan to make money. The Securities and Exchange Commission has decided to appeal the latest court decision in the Ripple case, even though it doesn't have enough evidence to back up what it says. But the agency is having a hard time showing that people who bought XRP thought they would make money because of Ripple's actions. The decisions made by Judge Torres said that Ripple's acts, such as selling XRP that was held in escrow, did not have enough of an effect on price changes to make investors expect to make money. At this point, the SEC's complaint will only work if the appeals court is sure that the programmatic buyers want to make money off of Ripple's actions. But the CC is going to defend this case even though the court didn't believe the SEC's expert on the subject. A recent tweet from Crypto Insight UK talked about shade Ripple's legal problem with the US Securities and Exchange Commission. This brings up an interesting question about the possibility of a deal between the two sides. Given the current situation, Ripple may change its mind about its stand. This company has said many times that it won't settle the case until it is proven beyond a reasonable doubt that XRP is not a security. However, recent changes in the law and the SEC's notice of appeal may have caused this change in position. The 2023 choice led to a lot of problems. According to the rules of the US Securities and Exchange Commission, XRP that is sold on secondary markets to regular buyers is not a security. In 2023, a move that was very important in the Ripple case said, this decision was a big win for Ripple and the Bitcoin industry as a whole. When the court said that sales of XRP to institutional buyers did count as securities, it led to a complicated situation. This outcome made it possible for both sides to think that their own outcomes were unfair. How the SEC's appeal and outside factors affected the case. Due to the SEC's subsequent appeal of this decision to contest the parts of the verdict that limited its ability to regulate XRP, Ripple has been under more and more pressure. The regulator is ready to try to get more legal clarity, and they have even tried to review those parts. To make things more complicated, Crypto and SciTuck have suggested that a compromise be reached. That is especially true if the appeals process lasts for a long time and makes Ripple's legal and financial responsibilities bigger. The deal meant that Ripple would not have to go through a long court case and would be able to get a more predictable regulatory decision. The result of the SEC's appeal is a key factor that could affect Ripple's choice. If Ripple thinks there's a better chance that the appeal will overturn some parts of the favorable decision, the company may decide to talk about a settlement. The lawyers working for Ripple, on the other hand, have shown that they trust the way the law is now. This is especially true since the court has said that XRP is not a security for retail deals. This gives them a reason to keep fighting. Also, outside factors like the Securities and Exchange Commission's ongoing investigations into possible conflicts of interest can make the regulatory landscape even more complicated. This is especially true for probes involving former department officials. If these reviews turn up negative results against SEC, the agencies may not have as much power to pursue the appeal, which will make a settlement more appealing to everyone. In the end, Ripple will decide whether to end the legal fight or keep going with it by carefully weighing the risks of the SEC's appeal against the possible benefits of ending this long legal process. This choice will eventually mean whether Ripple decides to end the legal battle or keep going. For now, XRP is still not officially considered to be a security for some sales. Still, the lack of clarity in the regulatory environment may push Ripple to seek a solution that will provide more market security. The expert opinion, which was a key part of the assessor's case, was found not to be reliable because it was not backed up by any evidence. The defendants were right when they said that the expert's claims about what a reasonable XR buyer would think to be true were not based on facts. A lawyer named James Murphy and another lawyer named Christy Warner talked about the SEC's appeal on the Crypto Law channel. The ruling that Judge Torres made in the Ripple case said that only sales to institutions were unregistered securities. There was no doubt in her mind that XRP is not a protection in and of itself. and that both buying and selling between private holders that did not include Ripple are not securities. He said that the Securities and Exchange Commission was very unhappy with the ruling that XRP is not a security. That's why they tried to file an appeal throughout the case. It wasn't a surprise when they sent in a notice of appeal the week before, which is the first step in the next steps of the process. While the case is still going on, the Securities and Exchange Commission will have to fill out a lot of paperwork after they file their appeal. James stressed that the situation with Ripple is very different from the usual and that the normal appeals process is still being used. As soon as someone sends a notice of desire to appeal, they have 14 days to fill out a certain form. There needs to be information on this form about the lawyers involved, the type of appeal, and the specific problems being argued. We should see this form within 14 days of the notice of appeal that was sent in the previous week. There are two big problems that are expected to come up with the appeal. The first thing that needs to be found out is if the trades on the secondary market that Ripple or its leaders started are considered investment contracts. Judge Torres said that they are not, but the Securities and Exchange Commission doesn't agree. A second issue that needs to be fixed is the lack of a disgorgement award. This award means returning money that was earned illegally. The Court of Appeals for the Second Circuit recently said that in order for disgorgement to be allowed, there must be identified victims who have been financially hurt. Surprisingly, after 4 years of lawsuits, the Securities and Exchange Commission could not name any victims in this case. Also, check out RippleVi's Sexy News for more reading. Key questions about the chances of a settlement and possible delays from the SEC's complicated legal problems are answered. It looks like the SEC's moves have hurt small holders of XRP more than they've helped large institutions. The information given is not meant to be taken as trade advice. Any purchases made based on the information on this page are not the responsibility of the people who made them. Before making any investment decisions, you should definitely do your own study and talk to a professional who knows what they're talking about.